To rock and roll?
Yeah.
All right. I am going to kick the things off here. Sit tight for just a second. Welcome to the smartest people in the room. We are so glad you are here with us. And just by showing up today, you are already demonstrating your very own smarts. Today, I'm pleased to feature two incredibly talented and knowledgeable music and content executives who have been at the center of the digital music universe for the past 15 plus years. I am so pleased to bring them together for what I promise could be CLE credit for many of you lawyers out there. And I promise you will leave today more smarter and more inspired than you arrived. Before we get started, please let me take care of some business. First, to the audience, please feel free to introduce yourselves in the chat window. The reason we do these webinars is twofold. First, we want to showcase really smart people and the amazing work they do day to day in the music industry. But the second reason is a bit more nuanced. Many of you know that I am a music industry headhunter. I run the music practice at Turnkey ZRG, and I place music executives in roles throughout the industry. So by definition and function, I help people connect with companies. And in this series, my goal is to help you make more connections, and I invite you to take full advantage of that opportunity. Specifically, I invite you to engage with the speakers and the other attendees in the chat of the Zoom. Please introduce yourselves, share your LinkedIn profile, say hello to your friends, and make some new ones. And ask questions of our speakers. We will try to address as many of those questions along the way as possible. Please make sure your chat is set to address everyone, not just the speakers. I want to thank our program sponsors, for without their support, we could not keep this series free. Special thanks to First Horizon Bank, Turnkey ZRG, the Tennessee Entertainment Commission, MedJet, Tennessee Brewworks, Project Music, and Cushmasters. So let's get down to business. In today's host seat, we welcome my good friend and fellow Nashvilleian, Colin Rushing. Colin is a seasoned music industry executive and lawyer whose practice focuses on music rights, collective management organizations, industry strategy, and business development. Colin was formerly the chief legal officer at Sound Exchange, where he was a member of the executive team, oversaw Sound Exchange's participation in a number of rate-setting proceedings, including those for satellite radio and webcasting, developed and managed the company's litigation and regulatory strategy, and supervised the company's day-to-day legal operations. Before Sound Exchange, Colin was an attorney at WilmerHale, where he focused on intellectual property and media law. He attended the University of Virginia School of Law and clerked for the Honorable T.S. Ellis III on the U.S. District Court of Eastern District of Virginia. He's on the boards of the Copyright Society of the South and Give a Note Foundation, and is a member of the adjunct faculty at Belmont University. Welcome, Colin. So glad to have you here with me, buddy.
Thank you. It's great to be here.
And joining Colin as today's special guest is Garrett Levin. Garrett is the president and chief executive officer of the Digital Media Association, the leading organization advocating for the digital music innovations that have revolutionized the way music fans and artists connect. Garrett's deep experience at the center of music licensing issues, pragmatic political savvy, and commitment to consensus building has earned him a reputation as one of the most trusted policy voices in the music industry today. Prior to DEMA, Garrett was Senior Vice President and Deputy General Counsel at the National Association of Broadcasters, where he led on all copyright-related issues. He previously served as Senior Counsel to Senate Judiciary Committee Ranking Member Patrick Leahy as a copyright policy attorney at the U.S. Patent and Trademark Office, and as a litigator specializing in digital copyright issues. Before law school, Garrett edited award-winning documentaries, including The Three Pickers and the Peabody Award-winning The Rise and Fall of Jim Crow. Garrett graduated with a BFA in film and television production from NYU. He holds a JD magna cum laude from Duke University School of Law and an MA in cultural anthropology from Duke. Please welcome these two rock stars to the smartest people in the room, and take it away, Colin.
All right. Well, thank you very much. And this is I'm just super delighted to be here with talking to Garrett and seeing so many people I know in the chat. It's too bad we can't be in person with everyone. It would be fun to see all of you guys in person. And so it's sort of wild. I've known Garrett probably for, I don't know, I can't even do math anymore, 12 years? Was probably
I think 14.
14. I've
Yeah.
completely lost track of time. The thing Tom didn't say was the pinnacle of Garrett's long and distinguished career in the music industry was when he was an associate at General Block, when he had the distinct honor of working for me when I was at Sound Exchange.
That's right. It's been all downhill since Colin was my client. But it's probably been all downhill for Colin since I was his lawyer. So, it's fair.
I'll just leave that there. But I do want to say, like, the thing that we didn't really get a chance to talk about in that sort of bio and Garrett's the resume is, I think, the original career path, which not many people know about. And I think I actually haven't talked to Garrett about this, was his original plan was to go into comedy as a stand-up. And so I had two questions for Garrett to start. Like, one, can you talk a little bit about that? And then two, can you confirm or deny that this entire career of yours is really about developing material for your future career as a stand-up comic?
Let me take them out of order, so I can deny that I'm only in here to gather material for a stand-up career. I've shelved that, but it is true. So I went to film school at NYU, and I went to film school thinking I was going to be a writer and director, and then I didn't actually want to do that once I was in film school, and I got really interested in some other stuff. But one of the things I decided I wanted to try to do to like fulfill a dream of mine, I had been an actor in high school, and I love making people laugh, and I was like, I'm going to try to be a comic. And ironically, this is the story I like to tell about this. I started doing stand-up comedy in New York City at the same time as one of my film school classmates, and we actually had the same work-study job. We worked together in the video post-production facility. So we helped NYU film students check in and check out of video editing booths. We had a couple of classes together. Very nice guy. And we both started doing comedy around New York at the same time. And I realized after doing it for a while that, like, and I think this is a fairly common thing among creatives. And I realized this, like, to really do it, to make a career of it, to make a go of it, you have to wake up in the morning and it's all you want to do. You have to like feed off of the chance to be able to do it. And by the by the resume and bio that Tom walked through, like pretty clearly, I'm actually not built for that. Like I'm built to like have a job and a paycheck and that kind of stuff. And the person who I started with at the same time, he was built to do it because he's Andy Samberg, he is a much more successful comic than I am, but I'm a much more successful lawyer than Andy is. So, I think it's okay. I think
right. It's like, really, who's winning in there?
Exactly.
That's a fair question.
Exactly.
So at what point did you decide to go to law school then? Like, when did that become the thing you knew was for you?
Yeah, it's a great question. It was like when I was interviewing to work at law firms, it was the most common question I would get. People would look at my resume and they'd be like, "You are a documentary television editor. Like, why do you want to work at a law firm?" And I was when I got out of college, I became a film editor, and I edited a series of documentaries that aired mostly on PBS. But the way I got to film school is via those documentaries and via that work. The first big editing job I had was on a series called American Roots Music, which aired in 2001 on PBS. And it was a 4-part series produced and directed by a man named Jim Brown, who's done a bunch of amazing music documentaries. And it was about the history of kind of American-born genres of music other than than jazz, because Ken Burns had just done 10 hours on jazz. So it's blues, bluegrass, country, Cajun, Zydeco, gospel. And what became really interesting to me as an editor and became kind of the gateway drug to law school is the fact that my job as the editor was to take the awesome talking head interviews that we had, the amazing archival footage that we had, and put it all together. And then there were producers whose job it was to get permission to actually use that archival footage. And they would come back to me and they would say things like, "Okay, well, we can afford 10 seconds of this footage. And I particularly remember I have this very vivid memory, which might be apocryphal at this point in time. And when I say it in this room, there might be somebody who's like, that's not true, but this is how I remember it. There's some of the only known film footage of some of the great American blues players was through German television, because they weren't able to be on US television during the 50s and 60s. And there's a guy who owns the entire archive of that show. And so I became fascinated as someone who didn't know anything about copyright and was just trying to put together a cool story with like, wait, how does that one guy get to decide who gets to view this? And so one thing led to another, and after another couple of years editing and realizing again that like I kind of wanted to, the issue with being freelance in something like editing is you're always wondering when the next job is going to come. When is the next thing going to be there? And it turns out my brain is wired to freak out about that question. And so law school seemed like a good way to marry a lot of these things and stay really involved and engaged in things like storytelling and the creative arts, while also making me a little bit less anxious.
That's fair. And so did you seek, so you knew you wanted to be a copyright lawyer from the very beginning?
I went to law school to be a copyright lawyer. Okay. Which I think, you're a lawyer as well. Like we could probably count on one or two hands our classmates from law school who went to law school with like a specific thing they wanted to do. A lot of people end up in law school being like, well, you're told it's a very flexible degree. We could spend an hour talking about whether that's really true.
Yeah. It's flexible, but then it also like distorts your brain, and you start to only be able to have conversations with other lawyers, and then you realize you have to sort of try to find ways to fix that. It's interesting because I actually never took a single copyright law class in law school. So it was, and the way I was always interested in new media and technology. And then I had an experience sort of early on in law school where I decided I was only going to take classes based entirely on who the professor was. And so, and that was how I kind of went through law school. But the thing for me, like my path to copyright law was frankly as like a music fan. And that was, when I went to Sound Exchange, I went there with basically no music industry experience at all.
I remember.
I had experience with copyright litigation. But I sort of like sought out like work in that space when I got to my first firm. Is that how it worked for you at Jenner, or did you end up?
It is, and you and I both had a similar experience of trying to be a copyright lawyer in Washington, D.C., which is not actually, a hotbed at the time. I think at the time, both of us went to law firms. It has changed a bit, but there were a limited number of options. I had not, I'd been a summer associate at firms in New York and LA. But my now wife, who I met in law school, really wanted to come work for the federal government. She's the daughter of a diplomat, and she really wanted to work for the federal government. And I was like, well, I'll try to find a job in DC. But yeah, I sought out firms that were doing copyright work in DC. But even then, my first year at the firm, I think I worked on like a case involving, it had nothing to do with copyright, it had to do with like helicopter blades. It had to do with, I worked on a case involving rural phone carriers and like potentially overcharging the larger carriers. But ultimately, like I ended up working on Sound Exchange CRB litigations. And that was kind of like how I got into this, like fully got onto the track to being kind of where I am now.
It's sort of wild. And you mentioned that sort of the role of storytelling and being a lawyer. And that's especially true in litigation. And it's something I didn't really appreciate until I got to a firm. And you're right about like the DC, like copyright world. It's so much more organized around litigation and the rate settings, which what most people think of as like traditional copyright work.
It's funny, when I was at NAB, I would get calls sometimes from, people who run radio stations or television stations who had like a very basic copyright law question about like the copyrightability of something or the use of something. And I was like, oh boy, I actually don't know the answer to that question. Like, you want to talk about like the rate setting standard for, non-interactive streaming? Let's talk about that. But let me talk to a copyright lawyer.
Yeah, I know.
It's a copyright question.
All right. So one of the things that that you've done, and people probably may or may not have known this about you, in terms of your path to where you are today, but it would have been clear from your bio, is you've worked with like people on kind of like all sides, right? So at Sound Exchange, it was recording artists and record labels. That's who you were representing. Then you went into government service. Then you went into working for the broadcasters. And then now you're working for the biggest digital music services in the world. And one question I have for you is, are there common threads that run through all of that work that you've done? And I'd also love to hear about like what you see as like the key differences.
Yeah, and I guess, when I think about the jobs that I've had, I think less about the for lack of a better description, kind of like which side of the table I was on or kind of where I sat at the table, and more about kind of like the commonalities of the experiences. I think it's right. And I think it actually speaks to a change in how the industry has worked over like the course of our careers. I imagine you heard some of the same thing when you started that I heard, which was kind of like, well, you have to pick a side. You have to pick a side and you have to like stick to that side. And I think, to a large degree, a lot of my career, it wasn't intentional. I didn't set out to say bullshit, like I'm going to do what I want. But I think there is some degree to which I think we see this, that the industry has become more intertwined and more interconnected in a way that is truly impossible to disentangle, that there is much more kind of cross pollination and movement among the quote unquote sides. But when I think about my jobs, I think more about like the people that I've worked with and the things that I've learned from them. And I've been incredibly fortunate that in every position I've had, I've learned from incredible mentors and leaders. I've been able to deal with really challenging problems and figure out ways to tell stories around those. Like, people would often ask me, well, like being a film editor and being a lawyer seems so different. It's actually not. It's like taking a pile of raw materials and telling a story out of that pile of raw materials. And I really actually love doing that. I think, one of the big differences as I've moved from litigation to policy to the kind of policy advocacy job, like government policy, to the kind of policy advocacy job that I have now, is how you define success, right? This is actually the biggest challenge for me, shifting from litigation into the policy space. In litigation, success is defined on whether you literally win or lose on like a particular motion or a particular case. And then if you lose, you just like complain about how wrong it was that you lost. But if you win, you're like, I won, yay. All right, what's next? In policy, there's very rarely someone who at the end of the day says, you're right, you're wrong. It's much grayer. You have to be much more comfortable sitting in that uncertainty of being like, well, we are moving towards something slowly but surely. And we think we can get there, but you can't define success by saying you won a motion for summary judgment, or you lost a discovery motion. I'm much more wired to engage in that gray space, although there are times where I'm like, I just need someone to tell me whether I won.
Yeah, I know, and I want to come back to that later, because you are right, and this is something like people, including myself, like unfamiliar with Washington can get very frustrated, because so often you can say, all right, this is clearly the right answer. There's an easy solution to this problem we've all been talking about for 5 years. So let's just do that. So I want to come back to that, because that is like, Washington just doesn't work that way.
Yeah, it doesn't.
Better or worse.
You've certainly experienced in your career as well, because you shifted from like litigation to like truly like in-house litigation to, as your role expanded at Sound Exchange, like being far more engaged in the broader policy discussions. And I remember many conversations you and I have had where you've been like, I don't get this town.
That's right. And that's why I'm in Nashville. No, it is true. I mean, there is this, I will say the one sort of downside to, that's not quite a downside with litigation, is it is so much, you do have that, like, it's either a high or a low when you get to the end of the case. And then there's that, then it's gone. You know what I mean? And you sort of like, the emotional rush sort of dissipates pretty quickly. And then you're on to the next thing, and that's good and bad.
That's the thing that ultimately made me leave litigation, is like I had incredible opportunities, primarily working for Sound Exchange, which is an amazing client that really did an incredible job of letting young associates like get meaningful experience. But I remember the last big case that I worked on was a rate setting for Sound Exchange, and I got to cross-examine an economist in the CRB, which is the kind of thing that like that's the kind of thing that a litigator is supposed to like live for. And I remember being done with it. And this is actually similar to the Andy Samberg story, right? I remember being done with it and being like, okay.
Right.
And I was like, maybe this isn't for me.
Yeah. Sorry, I'm going to go off topic. This is just for Kevin in the chat. Yeah, so I went to JMU, Kevin, and you can let everyone else know that as well. Go Dukes. All right, let me see. So I want to go back to some of like the policy stuff and the hot topics of the day in a few minutes. But before that, let's just talk a little bit about music fandom.
Okay.
And I would love, I don't know even if you remember, do you know the first album that you bought?
I do.
Okay. And by format, like, let's see, do you remember the first tape, record, and CD?
Oh, goodness. I don't know. I cannot remember the first tape that I bought. That's a great question. I don't remember the first tape that I bought. I do remember the first CD that I bought.
Okay.
How can you forget the giant box, right?
Yeah.
I bought, it was the Back to the Future soundtrack.
Okay. All right. I'm trying to like use that
to make fun of me.
To date you. No, that's actually like, so you were like an early CD adopter then.
I was a pretty early CD adopter. So my father loves music. My dad, I was raised in a house where music was always on. He had a pretty extensive record collection. And he's always been like a little bit of a technology early adopter. And so we definitely had a CD player fairly early. And I remember he was one of the first people that I knew who had he had this like 10 disc CD changer in the trunk of his car that you would like operate from the in-dash thing, but he would have to load because it was in the trunk.
Yeah.
you have to like load, you have to preload it, right? Because you can't, there's no changing it once you're in the car because it's in the trunk. And so I mean it's a good point. It's not something I'd ever really thought of, but yeah, I guess we had CDs before pretty early on.
Yeah, because I remember that was something I was the first one to have this CD player in our family, and I had to save up for it after my sophomore year of high school. So my first CD was Key Lime Pie, Camper Van Beethoven, and it's funny. It was honestly like, and I don't know if you felt like this with the Back to the Future soundtrack, but my current preferences for music very much trace back to all the time I spent with that CD.
Oh, that's a really great question. I would have to I still love horns and like you put horns in a song and like I'm a sucker for it. So like that's certainly a huge. I never really thought about it, but like I'll give credit to the news, not necessarily to Hugh Lewis, but like it really may have imprinted fairly early on me that like if you put horns in, like we're good to go.
Yeah.
That's a great question.
Yeah, I've sort of tried to figure that out because like the first tape I bought was Nucleus's Jam on Revenge, and there are definitely traces of that in what I sort of gravitate towards today.
I mean, I did it when I got my first Columbia House shipment, my 12 CDs for a penny.
Yeah.
There is definitely some like very, very powerful like female pop in there, which is still like a heart, like it's still like complete unguilty, like unironic love of mine. Like Amy Grant was definitely in that first batch of CDs that I got.
Yeah. Oh, that's good. Right. And it's fun. And then you sort of like rediscover that.
Yeah.
Later in life, right? Like
I'm rediscovering it literally right now, thanks to you asking me this question about whether like my music has been influenced this. But even before that, like my dad is a huge folk music fan. And you know, I think I can draw a straight line from his love of folk music and the amount of like Woody Guthrie and Kingston Trio and Pete Seeger that I listened to around, and Steve Goodman and John Prine, like that has like led me in a straight line to my love today of like Americana and like great, like just kind of singer songwriter driven guitar stuff.
And what do you do today for music discovery?
I stream.
I actually didn't mean to tee it up that way.
As the majority of Americans and so many other people, because streaming is incredible for discovering music. But it is. But look, I think I'm in a tough music discovery. I have to be completely honest with this group of people here who are watching this. I'm in a pretty tough moment on music discovery because I have children who are just about 9 and 5, and so like. There is a lot of Lin-Manuel Miranda played in our house in various different capacities. And my ability to actually just kind of like dictate what gets listened to, or find the time to listen to my own things. I get a lot of recs from friends still to this day. It's still like kind of my favorite way to learn about music is somebody I see somebody who, you know, often through like Twitter or something, I see somebody who I know and like who's like posted about something. This is how I discovered actually, I mean, lots of people are discovering him right now and there's a lot of press about him, but Barty Strange, who I like hadn't really been familiar with, and now I kind of have been listening to his recent album kind of on repeat. But I do find that as I listen to things on like a particular streaming service, I get to the point of like an album ending that I've listened to, and then the algorithm takes over and brings me recommendations, that I do find things that way, that I'm like, oh, that's interesting. I want to go check it out. I'm a pretty avid music, not just industry trade press reader, but just like kind of music news reader as well. And so I still read a lot of like music criticism and read a lot about, you know, what people are finding out there that's interesting. So it's a lot of that. How about you? Like, what do you do? I know you love music as well.
I do. Yeah. I mean, it's just sort of a mix. I mean, honestly, like my.
Wait, hold on. I have to say, Angela, you're trying to call me out. I actually listen to a lot of services. What I was saying in particular, I just meant like any given one. But it's funny because like that, because I spend different amounts of time on different services, the algorithms kind of treat me a little bit differently. One of them gives me a lot of Lin-Manuel Miranda. That's true. They don't all autoplay. You're fair. That's fair, Angela. Sorry. I felt a little bit attacked.
Yeah. No, I like that's a difficult position you're in.
Exactly.
It's funny. So I think you said this too. Like many of my favorite recommendations are from like just people I know and trust, and like so one of the things like. And just be like random things through Facebook, honestly, and especially when you get to know people in the business, like a lot of my favorite recommendations actually were just learning about who like John Strom was, like happened to be like working.
John's actually how I found Barty Strange, because John went on a kick of like posting about Barty's like over and over again. I was like, all right, I have to listen to this. And so I listened to it. But it's exactly like John is exactly how I found out about
you were thinking about it. I remember like I got to like, he was a leadership music classmate of mine, and he was like posting about Phoebe Bridgers when he was doing work for her, like before anyone else knew about her.
No, John's even here. John, give some recommendations in the chat.
Right there in the chat. But like that's the thing that I love about our industry is it's filled with people that are just music fans, and as well as like people that are music makers. And so like this is, you just learn things and I'm just a fan. You just learn things, and you learn you learn about these sort of like these veins of music you might not have otherwise even like discovered or known about.
Two things. One is I need to give a shout out, although I think she's now not in there anymore. Maybe she is. My old colleague from when I worked at the PTO, US Patent and Trademark Office, Ann Chadovitz is in the chat. Ann and I used to spend I'm not going to say how much, but a decent amount of time during our work days talking about music recommendations. So like Ann and John should spend some time in the chat just talking about music that they like.
That's funny.
And Kevin Clear has a question in the Q&A about recommendation of music press. He regularly reads follows. So I read, I really like Ann Powers, the music critic. I read Pitchfork occasionally, like I often will check out their reviews, just kind of see it. It's sometimes a little bit too snarky for me. I definitely read Billboard just to kind of see news stuff, and I like their profiles of people. This isn't necessarily, he's not truly just a music press anymore, but I just read this great book that I would highly recommend, which wasn't a real discovery tool, but it's an awesome book about music called Major Labels by, I'm gonna maybe mess up how you pronounce his name, but Kalefa Sena, who used to be the pop critic for the New York Times. And it's a look at popular music in the US primarily over 7 different genres. And it's really awesome. It's also part memoir. Those are some of the things that I kind of gravitate toward. Oh, and Stephen Hayden, who used to write for the AV Club, the Onion's kind of pop culture stuff, and now writes for Up Rocks. He's one of my favorite music writers.
Hey, the Wall Street Journal has weirdly great music criticism. I've learned there's a ton of bands that I've learned about from the Wall Street Journal of all places. And I love All Songs Considered. I mean, like it's sort of cheesy, but that's a nice. I find that to be a pretty fantastic way of discovering, like people new to me at least. For sure. So, and now I'm at a point. My kid is 18, and so we're like more and more like just comparing notes, and that's actually pretty fun.
That's super fun. My oldest is super into EDM, which is just really interesting. Like they really like it and have gravitated towards it. And it's a genre I've never really gotten into, but I find myself listening to a lot of it because that's what they want to listen to in the car. And it's just interesting to kind of see your kids' musical tastes develop.
All right, so now I'm gonna just shift abruptly to some of the hot topics.
Let's just keep talking about music.
We can come back to music and later or now. I can come up. Well, no, I can't come up with a good sort of actual segue. But so the so the Copyright Royalty Board, that's certainly in the news a lot. And in particular, the sort of streaming mechanicals proceeding, and it's super confusing now because there are actually 2 different proceedings that are kind of happening at the same time, and they're both, and one of them has really been cleaved into 2. So I just want to give you a chance to sort of set the stage a little for what you're seeing, and then if you just want to like talk about like the main issues that you're kind of like seeing sort of out there in the ecosystem that folks on this call might want to hear about.
Yeah, sure. And so this is an interesting time for me as someone who kind of cut their teeth in the music industry on these CRB proceedings as one of your lawyers, and it's been interesting to see the attention and focus on the proceedings grow over the years. When when we were doing them in the kind of earlier days of the webcasting, non-interactive webcasting proceedings, they really didn't get much attention at all. And still to this day, I don't think that the streaming, the non-interactive Section 114 streaming proceedings get anywhere near as much as attention as the mechanical royalty proceedings that are under the Section 115 license. And so we could spend, how much time do we have? We have only like 25 minutes. We could spend, 3 times that talking about kind of where things are and where things are going. I'll try to do a very quick overview of it. So the mechanical license, which is on the publishing side of the equation and is used for the reproduction and distribution of musical works in physical products, in digital downloads, in interactive streaming. That's a proceeding that there's a proceeding at the Copyright Royalty Board to set the rates for that. We are in the 4th wave of those, so Phonorecords 4, they cover 5-year periods. So we've got Phonorecords 3, which is 2018 to 2022, and Phonorecords 4, which is 2023 to 2027. Both of those proceedings are currently ongoing in some way, shape, or form. Phonorecords 3, which was decided initially by the Copyright Royalty Board back in it didn't actually get, the decision didn't actually come out until 2019, so already into the rate period. It got appealed to the DC Circuit. The DC Circuit vacated the CRB's decision, went back to the CRB for the remand proceeding. That has just concluded on July 1st. The CRB put out what they're calling an initial ruling. I'm gonna get like kind of in the weeds for a second, because I think unfortunately, all of us are suffering a little bit from an information deficit on this, including me and you, and like outside of about 20 people, everyone's operating in the same information deficit. And that's due to the fact that the thing that got put out on July 1st, which the judges have called an initial ruling, is actually only available to be viewed by the outside counsel to the parties to the proceeding as they work to review to see if any party's confidential information has been put in and needs to be redacted. So there have been a lot of press stories about what's in it. A lot of that is, all of that basically is kind of based on secondhand accounts. So I think what I would urge everyone to do is hopefully within a handful of days, we actually have publicly available versions of all of that. I wouldn't actually encourage everyone to read it. I mean, I would, but like you and I have both read enough of these in our lives to know that it's a pretty long slog. But once we have public access to that, I think we'll know a lot more about the nuances and details of what the judges did. Then there's a whole potential regulatory process related to rehearings, which are often asked for in these proceedings. There's a potential for another appeal, depending on how parties might feel about the outcome. And at the same time, the proceeding to set the rates for 2023 to 2027 is like well underway. The hearing was originally supposed to start last week, but there is a new chief judge for the Copyright Royalty Board who just started, I think, last week. And so that hearing has been pushed until sometime in September. It hasn't been set yet. So, I think there's a lot of directions to go in this conversation, and I'm sure I haven't had a chance to look at the chat. I'm sure there are a lot of questions about all the things that are going on. Maybe you can help guide me to like where you think it's best to like focus the energy and my long-winded answers about all of this.
No, that's it. I'm trying to. So I'll start with an observation. I'll just share a kind of a frustration as like when I was at Sound Exchange, there were these long decisions that would come down. And I remember when the Casting 4 decision came down and it was restricted and I couldn't see it. Mm-hmm. And we had, and I was the one having to make the decisions about, okay, what are we going to do about this decision? Because you have these sort of limited windows when you can work with that. And that's someone on the inside, folks on the outside, right? these decisions have an impact on the entire industry, and you sort of have to like read between the lines, and there's like, it can sometimes be unclear what can even be shared publicly. I guess we can monitor the chat to see if there are specific questions. I guess one big question is, as far as assuming that there's not an appeal of the Phono 3 decision, like what's it going to mean as a practical matter?
Yeah, so that is a really good question. And I think that there is a lot there for anyone in the chat who is a songwriter or a publisher or works with songwriters and publishers. I think this is top of mind. It's certainly top of mind for the DSPs, not just those who are members of DEMA, but kind of the broader DSP community. One of the impacts of the fact that we are now in 2022, in a rate period that ends in 2022, and I can't tell you exactly what the rates are today, that has an impact looking backwards to that entire rate period. So I think it's safe to assume, based on what we have seen in the press, that what the CRB has done has some changes to every year within the rate period. But it's important to think about like what has happened in 2018, 2019, 2020, and so on. So in that first period, 2018 to kind of August of 2020, the services were paying on the rates that the CRB set in the initial Phono 3 determination, right? So I have seen some comments, and I flag this here to this audience. I've seen some comments that say things like, well, the services owe all this money for the last 5 years because they were paying on the old rates for the early part of that period. My understanding, and I have no reason to believe this isn't the case, is that for that period until the DC Circuit threw out the rates, the services were paying on the rates. They were the rates. They were kind of the rates that applied, and so they needed to be paid under. The other thing that then happened, so you had the DC Circuit throw out the rates in August of 2020. The other thing that happened is in 2021, January 1st, 2021, the MLC. So Augie, this is kind of what I'm getting at a little bit here. I just saw this in the chat. For 2008, 2009, and 2018, 2019, and 2020, they were paying on the rates that the CRB set for those years. So those were the initial rates set by the CRB they ended up being in 2019, but it was retroactive to 2018. So they paid under I don't know what to call them other than like the old Phono 3 rates. Then the DC Circuit ruled on the appeal, found it was meritorious throughout those rates. And from that point, from August 2020 roughly forward till we have a final determination from the CRB, the services have been paying on what are called the Phono Records 2 rates, which are those that were initially established, I think, in 2008. And a shout out! I'm not sure if he's still in the chat, but I know Lee Knife was here, one of my predecessors at DEMA, who I think was around at DEMA during that time period. The other big thing that happened, in addition to the CRB throwing out the DC Circuit throwing out the rates, is that the MLC started operating in January of 2021, and the blanket license became available, and services began paying through to the MLC on the royalties that they owed. So this means a whole bunch of things from an operational perspective, particularly that we may be looking at 5 full years of adjustments. And I want to be clear, I'm calling them adjustments. It's not necessarily the case that it is simply a matter of services owing more money. This is a complicated rate formula. And given that point that I made before, that for 18, 19, and 20, they were paying on the initial CRB rates, to the extent the new CRB rates are different than those prior ones in ways that like change how certain things are calculated, it's not necessarily the case that it's simply a matter of services, quote, owing more money. And you then have the added issue on top of it related to how to make adjustments and make payments and reconciliations with the MLC under the blanket license. So, the services have been thinking a lot about the operational challenges here as an actual operational issue. And I know I saw Kevin Cassini, I think you were in there. Kevin Clay, you posted this, the letter, the variety piece on the senator's letter. And that senator's letter relates to a request that the services via the digital licensee coordinator made to the Copyright Office to look at how much time was going to be necessary to make these various buckets of adjustments across the different pools of time and pools of money. I can say, from my perspective, working very closely with these companies and thinking a lot about these issues, there is a deep commitment to getting these payments right and doing it as efficiently and effectively as possible. I think everyone kind of needs to recognize that this is far more complicated than just kind of updating a couple of rows in an Excel spreadsheet. This formula is, maybe I can, I don't know if I can say this officially, maybe I'll just say this in my unofficial capacity. The formula is unbelievably complicated, probably unnecessarily so, although I don't know what the alternative is. And it leads to operational challenges that I think I see folks like, Abby North in here, who I know, Abby, I actually just said this before you even posted that, that it's going to be challenging for publishers as well. It really is. It's going to be challenging for everybody to get this operationally right. And so what I hope to see is through the fog of the challenges around what the number is, right? Because look, you and I in various contexts have been involved in a lot of disputes about who should pay what and how much and when. Those disputes are kind of as old as the industry and will continue long past either one of us working in this industry. These operational questions, which in a lot of ways have become uniquely challenging and uniquely outsized in the digital context, I think require collaborative solutions and work to kind of by all parties to figure it out.
I will say, I'm going to answer. Thank you, Garrett. That was fantastic. Yeah. The one, George Schwinn asked a question, which I'll just go ahead and answer. He asked how does the Phone Records 3 decision get to stare decisis, where he says, how long can the appeal process go on? As a practical matter, it can go on forever. If you have a decision, then the other parties have a right to bring an appeal if they want to. I'll say in practice, it's pretty unusual, honestly, to have the DC Circuit reverse a decision of the Copyright Royalty Board. That was certainly at Sound Exchange, that was our experience. There might be sort of small technical things, but this was a little unique in the sense that the DC Circuit seemed to really throw out the sort of almost the core of the decision. And I'm not close enough to the details to really speak intelligently about why that might have been. But historically, the DC Circuit has not wanted to second guess the decision-making by the judges. Now, I will say one more interesting observation, though, and this is kind of an innovation, I think, on the last case you worked on, Garrett, for Sound Exchange, was the first time we had seen a dissent by one of the judges. And then that's now, I think we're now on 3 dissents total, right?
Yeah, my understanding is that there are 2 dissents it'll be 4 dissents total, because my understanding is that there are 2 dissents in this current decision.
Oh, okay. That's
how that works is we don't have access to it, so I can't exactly tell you, but if you look at the docket, there's an initial ruling, and then there are 2 different dissents.
There are 2 different dissents, and
yes, but the point you've flagged is right, that I'm not aware of any other CRB decision that has been vacated by the DC Circuit in the way that the original Phono 3 was.
Right.
And for those who are getting CLE credit, it has to do with the standard of review on appeal, right? They have to look for abuse of discretion for it.
Right. It's a very, very the one there there is the one sort of weird case where the decision was vacated because the CRB was deemed temporarily unconstitutional.
Yes. We worked on that one. We lost on that one. It got sorted out.
So, but let me ask you a big picture question about the Copyright Royalty Board process. I don't think anyone like loves it, right? Like, I mean, everybody sort of says this is what we've got and we'll sort of roll with it or whatever. And as litigators, you sort of work within this system that's before you. But just speaking as yourself, maybe, you know, like, do you have a sort of like a couple of wish list items about how the CRB process might work better, or what some goals might be?
You know, I thought about this a lot when I litigated these cases. And even, you know, one of the first things, you might remember this, Colin, but when I went to work for Senator Leahy, one of the first things I thought about trying to do was like a bill targeted at CRB reform. Mm-hmm. I spent the last couple of days trying to remember what I thought were good ideas at that time. I think I even asked you if you could look in your files to see if you had some sort of email from me. But I don't remember what those were. And I'll be honest that I'm a little bit too far removed now from the actual proceedings. Like DEMA doesn't actually participate on behalf of its member companies. They, you know, in contrast, so in the litigation, NMPA represents the publishers, and NSAI participates directly. The DEMA member companies all participate on their own and file their own cases. And so it's been a while since I've been close enough to the actual like nuts and bolts of the litigation. I suppose if you forced me to answer this question, not that you're actually doing so, but I do think thinking about reforms that incentivize settlement possibility in these contexts. I think it's unfortunate that in many respects, the way in which we approach the rate setting has become less a matter of setting rates and more kind of in a lot of ways, a little bit of a dueling PR battle about, you know, who is or isn't right. And I think having it be an actual proxy for what it's really trying to solve for, which is the difficulty in solving these questions through commercial solutions, like direct commercial solutions. That's why we have statutory licenses in the first place. And that's why in statutory licenses, we have ways to set rates in the absence of agreement. But the ideal outcome in any scenario is an actual agreement out of it, not litigation.
So I know Tom is trying to figure out whether to go a little bit longer.
Yeah, that's fine. I'm good.
Okay. Yeah, it's funny because I think if, like, you know, my sense, and I didn't work on, I mean, I was not working on music issues when I was in law school, when this, like, when the system was first created. But my sense is that the sort of big picture idea of how the CRB process was supposed to work was that you'd have one, maybe two proceedings, and then that would kind of set the expected outcome, and then there'd be settlements after that, right? And that's sort of the ideal. In practice, it just hasn't worked that way. And from my perspective, the ideal reforms, as you said, are things that just make settlement more likely. I think that works better, because going back to the operational thing, it's one thing for the Copyright Royalty Board to come up with a rate, right, a number. Mm-hmm. It's another thing to actually expect a third party to come up with not just a rate, but the way that the sort of whole system is supposed to be implemented. You know, I mean, like it's just incredibly complicated, and to try to do that through a litigated process is arguably, I don't want to say unworkable, because it's happening, but it's not like it's not a recipe for success.
No, it's totally true. And, you know, I see not to call him out, but I see John Riley in the chat from the Copyright Office, and not that John's responsible for the Copyright Royalty Board at all, but I was going to draw a slight analogy. You know, the Copyright Office has done an incredible amount of work over the last handful of years on implementing the Music Modernization Act through just a massive amount of regulations. And I'm not, I'm not putting John on the spot here, but I have to imagine it was hugely challenging to sift through and navigate a lot of those regulations were focused on solving for operational questions, right? And this is true in legislation, it's true in regulation, it's true in litigation. When you are trying to solve for operational challenges in a particular moment, the solution might work well for the question is exactly as it is presented, but it might not actually allow flexibility for the way it works in the real world. And this is something that I think is a challenge that the industry has been wrestling with since streaming came along and kind of the rise of streaming. And I think it's only going to get more challenging through more and more digital distribution, which is balancing an unbelievably, and I think from my perspective, overly complicated legal licensing landscape with an incredibly demanding transactional and operational landscape.
That's a really good segue to the next topic I wanted to get to. So Tom, how much longer do you want to go? All right, we'll just see. All right, so I'd like to talk about the Music Modernization Act.
Yeah, sure.
And so, and I was thinking about this sort of metaphor, which is a little bit rough, but the music industry is like in all of these sort of systems we're talking about, they are these sort of systems, and it's sort of unique as an industry goes, in that you have this like network of intermediaries and statutory licenses and existing industry practices, and they've been around for decades. And since my dad was a civil engineer, I often think in terms of like transportation, and also because I'm a cyclist, and so I think about roads all the time. And there's a way to think about the music industry and all of these rules as almost like a transportation system. The Music Modernization Act was one of the most important pieces of music-based legislation, probably, certainly over the last 20 years, right? And arguably even going back further. But my question for you is, on a scale of 1 to 10,
boy, okay,
through the lens of a transportation system, with 1 being, and let's talk about like reform, like if 1 being filling in potholes,
mm-hmm.
and 10 being a complete reimagining of the system, akin to replacing cars with teleportation devices and replacing roads with public transportation system and having systems where everyone can take scooters wherever they want. Where does the Music Modernization Act fall?
Oh my gosh, that's such a good way of asking that question. And I haven't actually, I've never thought about it in that way. I would put it at, I think I'd put it at a 7, a 6 or a 7, okay. Because I think structurally, there are things about the Music Modernization Act. For example, the fact that we are talking about a blanket license, the fact that we are talking about a single point of administration on both the service side, licensee side, and the rights holder side. The fact that we have a mandated publicly available database that incentivizes work on both sides of that equation. I think those are things that like truly reflect meaningful progress in terms of like the kind of complicated patchwork of roads that we were trying to use to kind of conduct digital commerce on the music publishing side. Where I think it's kind of hard to give it a 10 is not about the MMA itself, and certainly, just to be really, really clear, not about like the MLC or anything related to that, but more about the fact that what it still retains the generally siloed approach that we have developed over the past 100+ years for music licensing of attempting to definitively cabin certain rights in certain works for certain uses in ways that subject them to certain treatment different from other treatment, right? So, you know, in the pre-streaming era, you could put up a chart, and I know we both know someone who has a very good chart on this,
yeah.
where you could kind of take the two copyrighted works, the sound recording and the musical work, and the kind of two basic buckets of rights, performance and reproduction distribution. And you could put a given distribution path into kind of like one, maybe two of those quadrants. And so you could say, here are the rules for dealing with that quadrant for that distributor. And it actually worked fairly well. What happened when on-demand streaming came along is it mushed all of that together in a way that you couldn't easily fit it into one or two quadrants. And there were questions about whether it actually implicated a particular quadrant. And so the Music Modernization Act, I think very elegantly solves for some of those quadrants. But it does it for on-demand audio streaming, right? And I saw somebody, I think Abby, you mentioned Web3 and the metaverse and things like that, right? Like video isn't implicated by the MMA. Metaverse stuff probably isn't implicated by the MMA unless it's pure audio transmission. And so I think the things that we've done in the MMA, when you think about the things and the structures, are like, they are truly modernizations of the way we operate licensing in this context. But they are modernizations on top of that same essentially unchanged legal landscape.
Yeah, I agree with that. I mean, like, I think my take is the Music Modernization Act, which I still think it's an amazing thing that it became law. It was, I think it's actually I don't know if everyone on this chat, probably everyone on this chat on the Zoom appreciates this, how unusual it is to be able to get a consensus in Washington about anything, and to have this legislation come together the way that it did and on the timetable that it did was pretty extraordinary. The thing I liked about it, and I still like about it, is and I'll tell you, like, this will make sense to the DC people. I feel like the Music Modernization Act reminds me a little bit of what happened with the mixing bowl in the Beltway. It was this incredible effort to correct how the Beltway worked, right? It was not really a reimagining of whether the Beltway is the right thing to have. But the changes were so important. So you mentioned all the things that happened on publishing. The other thing that it did that had been a priority forever was on the sound recording side was making it clear that pre-72 sound recordings could be sort of brought into that kind of 114 system. But one of the things that's interesting in music, maybe I don't know if this is interesting or not, like in some ways things would be simpler if we had like a single like Ministry of Music, right? Where you could go and fix the whole system, or to have nothing at all. But instead, the actual fact is, like, the way the music business is organized is it's spread across all of these different legal regimes. And so you've got the CRB, you have the Copyright Office, you have state laws that are still implicated. You've got, then you've got I think I mentioned the consent decree regime. You've got all of these different things, and they're not really sort of coordinated or organized.
Because, I mean, if you think about how they came about, they didn't come about in a coordinated fashion, right? They came about in these incremental ways that I think reflect the kind of general approach to a lot of policy making, like not just in the music space, frankly, but I think we keenly feel it in the music space, where the goal of a particular policy is to address the specific problem in front of them. And like I think one of the really cool things about music, and it is very cool as a music fan. It is very cool as like an innovator. It presents challenges in these policy spaces, is that music has always been at the cutting edge of technological evolution. I think in large part because at its core, it is a very small individual product, if you think about it in size wise, right? So like particularly in the digital space, music is almost always at the forefront of whatever the next technological innovation is, because the file size of an individual piece of music is much smaller than the file size of any audiovisual content, which allows for incredible innovations for consumers, incredible innovations for artists. But the history of the industry, particularly over the last 25, 30 years, is one of like that technological evolution outpacing the kind of legal and regulatory landscape.
So I think we're probably starting to lose people, but I wanted to, why don't we so I'm going to say one thing going back to an earlier topic of music discovery, which I meant to say but forgot to, which is actually go see live music and go see the opening acts, because that's when you're going to discover artists that that might not be on your radar screen but are probably in the orbit. You're welcome, Toby. And then
what a Toby club in Iowa.
That's true. But what I wanted to give you for your last word, Garrett, is if you want to talk about some of the sort of like maybe non-policy priorities that DiEM is focusing on and working on. You are a trade association, and it's not all copyright royalty board and legislation. So what would you like to leave us with?
That's true. It is not all copyright royalty board and legislation. It's so sad that it's going to be ending. This has been really fun. What are some of the other things that DiEM is working on? So look, I think one of the coolest things about streaming is that we have, and I think it gets a little bit taken for granted, we have access to like the history of recorded music in our pockets. And that's truly amazing. And we are spending a lot of time at DiEM thinking about what that means. Like, what does it mean that we like to be stewards kind of that history of recorded music? So for example, we did something that I thought was really cool last month as part of Black Music Month, where we had an ethnomusicologist write a blog post about the history of Mississippi Hill Country blues, and put together a playlist for us of that like very, very specific genre. And what was to me one of the coolest things about that process is she put together this playlist, and I'll confess this, she gave us this playlist of like 20 tracks, and of those 20, we couldn't find one. There was one single one that was not available on the DiEM member company's services to create a playlist for people to do. That's really cool, right? As a music fan, as a consumer, but also as someone who's like thinking about discovery, thinking about access, how do we find ways to tell that story? And also, think about other types of discovery. One of the, to me as a fan, but also as an advocate, the idea that if I think of an album that I want to hear or a track that I want to hear, I don't have to go to my closet where, yes, they are, my binders of CDs are, and like pull out the CD, like flip through it till I find the right CD and put it on. Like I can rediscover like something I've loved for a long time at the push of a button. And thinking about what, setting aside just like the kind of economic conversations about that, and there are economic conversations about it, and we're definitely involved in those, telling the stories around what streaming means for fans, what it means for creators outside of, the kind of never the evergreen conversations around rates and economics. I think that's a real focus of the organization. So We've got some consumer research that'll be coming out at some point this year. We've got some cool reports that we're working on. But I don't think as an industry we're doing ourselves any favors if all we are talking about collectively is like a one particular rate set in one particular process. We have to find ways to leverage what it means to like have the amazing innovation of streaming for the betterment of the industry going forward.
All right. Thank you.
Colin, you want that to be it?
I think that's a pretty good note to end on, Garrett, if that's good with you.
I'm good. I like talking about this stuff, so.
Well, I'll tell you what, guys, there's enough demand for part 2 of this one, I know. So be ready for me to circle back to you and ask for another date. This has been outstanding. Thank you so much. Well, you are clearly the smartest guys in the room. I knew you would be, and you've demonstrated that in spades. So thank you.
Thank you, Tom. Thanks for having us, really.
Thank you, Tom.
Absolutely. To the audience, you got yourself a full dose of CLE today, plus some great inspiration. So thank you to everyone who participated today. Be nice to each other and vote your ass off this fall. That's all I got to say. We'll see you soon, folks.
All right. Thank you.
Thanks.